This is the current federal tax developments for the week of August the 26th, 2024. Current federal tax developments are brought to you by Kaplan Financial Education and by your state society of CPAs. It's Zollers, and we're coming to you this week again from Phoenix. And yeah, I had a little off last week. We had a couple things get in the way, so things didn't go out on time. But this week, we're going to talk about some developments in the area of the employee retention tax credit, because after everything kind of has set quiet for a while, we did have 2 weeks ago, we mentioned the IRS began to give us a notice about what they're doing. And this, we're going to talk about what the IRS has additionally announced in the interim and the reaction of the National Taxpayer Advocate to what the IRS has done. So we will talk about the IRS's reopening of the ERC Voluntary Disclosure Program. This is part two. And we're going to talk about the fact of there are somewhat less generous terms and somewhat less broad of coverage. But the program is still much like the first one. We'll see if we get more response this time or how things move forward. But it'll be interesting to see what goes on here. Also, the National Taxpayer Advocate issued a blog post this week, which was interesting, and they discussed the IRS's disallowance notices. Remember that was part of what we discussed 2 weeks ago when we talked about the fact the IRS has now said, hey, we're going to issue these disallowance notices for these claims that we believe are overwhelmingly unlikely to be proper. And then we're going to, start processing those refunds, etc. So we're going to talk about the National Taxpayer Advocate. It's an interesting blog because it contains some important pointers for anybody who has received one of those letters, especially about the fact that something some professionals may not be aware of, in that appeals works differently in this regard, at least in terms of the possibility that during appeals, the taxpayer might lose their right to claim the refund. So we'll talk about what you have to do and what you have to watch for. It's kind of the backwards if you're used to the traditional system, where the IRS is examining a tax return, they propose an assessment, then they issue the 30-day letter. You have a right to appeal, and while appeal is pending, there is a risk for the service that the clock might run out, but there's no risk for the taxpayer because only after appeals has ruled in the case will there be a 90-day letter issue, which starts the clock on when the taxpayer can file in court. As we'll discuss today, the National Taxpayer Advocate points out that in this situation, if you're not careful, and especially because we would expect to have a rather large number of the cases appealed from some of the CPAs I've talked to who have had clients who've received the rejection notices in this round, it may be very, very crowded at appeals, which is normally crowded anyway, in order to get your case heard. And that may cause some real problem with the timing rules we have to worry with. So let's go ahead and get started. First, discussing the brand new second pass voluntary disclosure program for the employee retention tax credit. This is the second program. It is reopened. You'll find that it's very similar, but not quite as generous. The IRS announced this in IRS News Release 2024-213, and the details of the program are contained in IRS Announcement 2024-30, and this came out on August the 15th. The IRS had decided now, and this is what they announced, that they are going to have a second ERC Voluntary Disclosure Program that they will open up. Like the first program, this program will run for, in this case, just over 3 months. They announced it on August 15th. They give us until November 22nd to have claims to put our application in if we wish to be part of this program. So again, it is a 3-month run again, and there is discussion about, you have to discuss with clients again, even though they decided not to do the first one, because by the way, as we'll discover, if you did go into the first one and you just haven't heard yet, no, you don't throw into this one. This is not going to give you a second chance, right? If they reject you on the first one and you'd applied for the quarter, any quarters you applied the first one that they reject you on, that they say, no, you won't be part of that program, you can't come back here again and try a second time. Put it that way. We'll be there. Now, other issue is it only applies to claims for the 2021 credit. So if you've received a refund on the 2022 employee retention tax credit claim you have, you are not able now to give voluntary disclosure, go ahead and put the money back in. My guess is the IRS is looking at this from the standpoint of, look, the statute really is closed on 2020 at this point for purposes of filing a claim. Refund claims probably for 20, for the most part, went out quite a while ago, or they're stuck in this big stack to be processed. But people probably don't have a whole lot of 2020 claims. The 21 claims were higher, and the statute is still there to file them. So, in essence, they're going to do it this way. But for whatever reason, because they don't really explain why, even if your 2020 refund claim is still within the statute, your 2020, just a refund claim, but your 2020 refund that you received is still, has been received less than 2 years ago, the IRS can still basically examine it and ask for the money back. They're not going to let you volunteer into this program at this time. Obviously, you could just decide to send it back, but you're not going to get the breaks. So again, that is also somewhat less generous. You have to be aware of that as part of it. And the other thing that makes it less generous, and this is one that was totally expected, is that we are going to now, instead of under the original program, the employer, let's say they got a refund of $1 million, they would have had to pay back only $800,000. They would have been allowed to keep 20% of the credit, essentially to help them deal with the fact that they probably paid somebody to assist them in filing the claim. And the idea was, well, this way we're only asking for the money back that they got a benefit from. But that 20% was across the board. If you didn't pay anybody to assist you, you still could keep 20%. And if the person you brought in to assist you, was claiming 40% of what you got, well, you still had to repay 80. You still had to, it didn't matter that they took more in fees. This was just a nice, simple area, a kind of number that was meant to be close. Well, you snoozed. You didn't go in right away. If you want to come in now, they're not going to be as generous. That's generally true of most amnesty style programs, and this, for all practical purposes, is an amnesty style program. You're allowed to come back in from the cold, and the IRS does have a tendency to open these programs back up after they're in, but every time they open it up, it is less generous than the last time. In essence, they're trying to avoid creating an incentive to wait for a better deal. They're not going to change the program to give those who come in now a better deal than those that came in the first program. So right now, therefore, if you skip the first program, but now you're getting cold feet, well, of that $1 million refund, that claim you had, it's going to cost you now an additional $50,000 to come into under this program. You'll still keep 150, but you would have kept 200,000 before. So, again, not to encourage you to wait out and wait for a better one. They're trying to tell you that if you let this one close and then, on the hope they'll open a third one, that third one will be even less generous and certain other things may disappear. If anything, I was somewhat surprised that they actually kept a lot of the things they did, that a lot of the other provisions in the program were not made less generous. They weren't made more generous, but they didn't become less generous. And I think that's actually important to understand. So it's still relatively a good deal, certainly a better deal than you'd get if you lose. Now, again, it's not a good deal if you're going to win, if you would prevail. It's not a good deal if you would never be examined. But if your client has become nervous and just doesn't want the uncertainty, and in some cases, there's going to be a problem because buyers, potential buyers of the business may be nervous if there's an ERC claim out there, that the IRS could potentially examine this business, could potentially come after it for, ERC payments. And they might be a little nervous about whether or not they can really get this business clean of any problems. And that may also cause some people to say, yeah, if I want this sale to close for 40 million, I'm going to just kick the 850 back in, get out of it. So I'm no longer exposed, and that's off the table in theory, at least, for the IRS coming back in and doing the exam. So that's what we got. Now, Again, under this program, the employer will not be charged interest or penalties as long as the entire balance is paid at the time of signing the closing agreement. If the taxpayer cannot pay the entire balance due when they're signing the closing agreement, and that's how you end this thing, the IRS accepts you into the program, you and the IRS will sign a closing agreement. A closing agreement effectively ends everything. You can't go back and claim refunds again. You can't go back and try it again. But let's say that you come into this program, you pay back the $850,000. Then next month, a court case comes through that had your exact fact pattern effectively that you were concerned whether that would qualify as a partial disposition. That case goes in the taxpayer's favor, and maybe it even goes to the Court of Appeals that is in your area. And the Court of Appeals says, yep, that's proper. IRS, you're wrong. You can't go back and apply for a refund, even if the statute otherwise still be open. Sorry, guys, done. You sign this, end of game, we're over. The closing agreement's in place, and you've agreed to give up any claim you might have for that year when you come into this. It resolves everything finally, but it does mean finally. If you don't have the money, the IRS will consider, but you'll have to prove economic need. You'll file an installment agreement, file the financial statement information, etc. And you are going to be charged now, failure to file, not failure to file, but failure to pay penalties and interest, it would appear, starting from the date of the closing agreement. So they will start charging you then. So if you let it go beyond, you're not going to get this deal. This deal wipes all, there'll be no interest, no penalties, you're done. If you can't pay it up front, then again, they don't say that it would start only at the date of the closing agreement. I'm assuming they would likely do it that way. But you certainly would clarify before you signed off that it doesn't mean if we can't pay up right now, that we're going to go back and get all penalties that could be on the table back to, the first day, the day we got the refund, all of those could apply. Then, you might say, well, that's way less generous, or it might encourage the client to try to find a way to find the money without borrowing it from the government. We will also not have to repay any interest that the taxpayer received when they got their ERC refund. Generally, you get paid interest because the IRS, takes time to process the claim. Because the claim was filed, there is a time period before your client had the claim approved and paid. There would be interest paid to the client. Traditionally, if you are found that that claim was paid in error, you would have to pay back that interest that you had received from them, because it's like, nope, you shouldn't have gotten that. Right? That interest should not have been paid to you. So essentially, otherwise you're getting a windfall because, okay, yeah, you're paying back $1 million. Because it took the service 8 months to get through your claim, you have 8 months of interest there, that you were paid for, because the theory was that you were owed that money, and now we're saying you weren't, so you need to return that interest as well. But you won't have to do that if you come in the voluntary program. And that is the same as it was in the first program. No difference there. Again, you will have to provide the names, addresses, telephone numbers, and details about services provided by any advisors or tax preparers who advised the client or assisted them with the claim. So note, like before, that would include if, and there were some CPAs I knew that went along with this, where the outside consultant, did the work, went in and came up with the claim and said, oh, this claim is right. This is the amount of refund, but then had the CPA prepare the 941X because the consultant would tell you that it was illegal for them to prepare it. By the way, that absolute garbage to say that they couldn't prepare it. And that should have been a huge red flag to the CPA, and the CPA should have told the client that that was a huge red flag. Why don't they want to sign the 941X? And it's like, they don't believe in standing behind their work. They want to make sure that they have full deniability effectively. And rather they want to sacrifice somebody else. I'm sorry, client, I'm not going to be sacrificed on this issue. You're sorry, you do it. If you go ahead, you can prepare the 941X yourself. Usually as skeletal a claim as they got, you could say, you guys can do it, do it. Go down that route. So you have to turn everybody in. right? Everybody has to be turned in. That is a requirement. Obviously, the point of this from the IRS's perspective is to start developing some evidence that they hope will help them pursue certain actions against certain advisors. So be aware the client is turning in the advisor. That also means, though, you need to be careful if the client about advising the client if you were involved in a successful ERC claim. You're in a conflict situation if you start advising the client about this program. And that gets really touchy as to where you're going. Obviously, because believe me, the client will probably get no benefit of having consulted you about whether they should go in the program. IRS will say tough luck. That doesn't matter if everything goes against them, because then the IRS will say, well, you were getting bad advice anyway, and this let you get out of bad advice. So you might want to suggest to the client, say, look, I believe this is wholly supportable. I believe it's there. But, if you want to be safe about what's going on here, you might want to ask a third party to review the claim. And you will pay them to do that, and they would be the party who could help you decide if this is something you should be doing or not. Because that is a key issue, how it would work in that mode. It is reviewing your own work, unfortunately, is a conflict of interest. Advising a client whether they should turn you in, that's kind of an obvious conflict, right? Saying things like that. So again, I'm not suggesting that everybody that advised on this was somehow, a cheat. There are very, very good programs, very, very good consultants out there that did this work. But, you just have to realize that, bad consultants would swear everything's perfect too. So you have to tell the client that as well. There were fly-by-nights. They would swear everything's perfect too. If you really, really want to make sure and you're worried about this, I would suggest you have an independent person review this. Now, it's going to cost you, right? There's no question for that. It's going to cost you. But having paid an independent person to review this, that would be your best protection if the service later throws a book at you, because then at least you could say, look, I sought other advice and, I got this from somebody who didn't have any, didn't have anything to gain or lose by telling me it was good or it was bad. They were going to get paid for this analysis regardless. Okay. Now, other things, you must have received an ERC refund, right? You had to receive the credit for a period in 2021. It could have been a refund. It could have been on the initial return. And you must not have already applied to the first voluntary disclosure program for that period, right? The IRS is still processing those at this time. So the fact you have not heard back from the IRS does not mean they don't have the first one. They do. Hopefully you kept records and proof of the filing of those documents, kept everything you got, the electronic filing information, all of that data. So if you had to, you could prove it. So they're saying, but if you applied for the first one, like I said, this isn't a chance that, hey, let us go play the lottery and see if we throw it in front of somebody else and maybe get them to say, hey, yeah, it's good. No, that's not going to happen, nor are you to file them to try to speed the process up. In all likelihood, if you filed again, almost certainly gum the works up and just totally mess things up and slow things down dramatically. Again, slowing things down dramatically, yeah, might not work to your benefit. We'll talk about that later. We're there. Now, the employer cannot be under criminal investigation. If a criminal investigation has begun with regard to you, you're not going to be able to participate in the program. And that's going to be important to understand. It might be an issue why if the service rejects you immediately in this program, get legal counsel, because that may be an indication that either you are already under a preliminary criminal investigation or, right, you have those issues, or we have one other issue coming up. You cannot also be under an IRS employment tax exam for the period which you're applying for the program. If the IRS already notified you're going to do an employment tax exam, let's say, for all 4 quarters of 2021, tough luck. You got this refund. You're already under exam. You can't say, oh, I got the exam notice. I'm going to go ahead and volunteer. That's not the purpose of this program. It's not to get people who know they've been caught, to come in from the cold. It's meant to get people who are out there and don't want to play the audit lottery at this point and are concerned. And so we have to worry about that as to what they're going to do in that area. Okay. You must not have received a letter 6577-C, which is the Employee Retention Credit Recapture, or an IRS notice and demand for repayment of part or all of its claim. If they have told you, send the money back already, no, you can't go to this program. Again, same deal here. If we know you've been caught, it's too late. You can't get into this program once you know that you've been selected. Once you know they want the money back, it's too late to say, can I get that really good deal? No, the really good deal is only if you come in before these things happen, right? You haven't already filed an amended return to eliminate their ERC. That one is one that could accidentally cause clients to come into the program. You might, that's going to be one where maybe you try to negotiate with the service, saying, look, I could have come to the program. I just didn't know about it. So I'd filed an amended return. This is not fair, et cetera, et cetera. You might get a little bit of leeway. Not sure. I'm pretty sure the service will tell you that they can't waive the interest in that one. And so in general, even though they are under this program, but so you may find some issues. But yeah, that one is one that just could be bad. That could also be very bad for let's say a CPA or other advisor who hasn't kept up, doesn't know a new program's out there, and is having the client file an amended return at this point. Instead of considering the program, yeah, I can see some problems there and damages, right? And this is the other one. In addition to that issue I told you about CID, basically already having your file in front of them and looking at it. The second one you're less likely to know about. That is that they've received information from a third party or directly from an enforcement action that you're not in compliance. If somebody has turned you in, you're not eligible. If there's a whistleblower who said, hey, XYZ company here, I know they got the credit, and I know that they, in essence, they did it in a way where it's non-compliant. So a whistleblower turning it in, if that process is that's going on, somebody has already turned them in, you won't be there. That's also a reason why, if you're rejected, they're probably going to tell you this is the reason you're rejected. Or say, sorry, we've reviewed your application, you're not eligible. Especially if they're not telling you why you're not eligible, definitely get legal counsel to review everything. You have to presume there is a chance there is a criminal investigation, potential criminal investigation underway. That's why they're not going along with this. So, as I said, that would be a huge warning if you got it. You again will use Form 15434, Application for Employee Retention Credit Voluntary Disclosure Program, submitted electronically to apply to enter the program. That you'll provide all the detailed information there. It is the same form it was last time. You must download it. You must use the PDF. The PDF has automatic calculation parts in it. So, you go ahead and you use that. It has the information. It's automated, so it can add additional schedules. So if you had more than one advisor, while the base form shows only one there is a button to add another. And if you do that, then yeah, another one pops up, etc. So it works very much like if you've looked at the BOI reports from FinCEN, yeah, it works a lot like that PDF. And you will be filing this thing electronically. You will submit it electronically to apply to the program. That does mean you need to file it electronically by the deadline, November the 22nd. Cannot mail this thing in. Or as I recall, I'd have to go back and do a total double check. I vaguely recall there was some way, maybe if you had to, you could get it done that way, but that's not really the way it's set up to run, and it is a discretionary program. So generally, get it filed electronically if you're going down this path. Now, if you have outsourced your payroll to a third party, and that third party reports, collects, and pays the employment taxes on their own, on your behalf, but using the third party's number. That'd be in many cases, we're going to talk about a situation for, like a PEO. you have to have the third party has got to submit the 15434. So because it's their EIN. Now, both you and that third party are on the hook for this. That's the weird part about how the credit works. So that's why, but it is their number. Since it's their number, their report, they're the only ones that can file it. So if you go in that route and now you're saying, hey, I don't think we qualify, you need to start talking with your payroll tax provider. Now, the only, I guess, good news there is most of the POs have said that the IRS has moved so slowly getting refunds in those cases to the PEOs that probably you're not in a position to go in this program anyway. But if you are, be aware of that if you've got that in front of you, but your payroll taxes are being filed and paid under a third party's EIN because the third party is essentially your payroll company. You need to be aware of having to have them file the claim. Somebody authorized to file the 941 is the party that can sign the 941X. Basically how it's going to work. Big thing to remember about this program, it does not provide protection from criminal prosecution. So if you're going to provide all this data, if the IRS takes a look and says, these guys obviously had to know that this wasn't legit. They had to know, and they were acting total disregard for the law or an active knowledge that the law, that they weren't justified in getting this. We think we should criminally prosecute them. We want some examples out there, which, by the way, Justice Department always likes to have examples out there of people. If that's the case, then going in this program is a problem, right? You need to be aware of that. You need to get legal counsel involved. I suggest entering this program. We're talking about significant funds generally. I suggest that you want to bring legal counsel to the table. Couple of reasons to do that. If this goes south, in essence, to get examined whatsoever, you may need that counsel involved anyway. So kind of useful to get them in now and look at it. It's also helpful for them to review, especially if making sure they have background in knowing how criminal prosecutions come about, to make sure that this does not appear to be a case that the IRS would decide would be a criminal case. Generally, and talking with some people in CID and those who have prosecuted cases before, generally they're looking for a winnable case. And they know that a winnable case in front of a jury, they're especially looking for cases where somebody got the $850,000 and went out and splurged on things utterly unrelated to the business. They went out and they bought, fancy cars, they bought homes, they bought jewelry, they bought all this stuff, splurging it. Oh, and they probably, paraded around and, bragged to their neighbors about, what they did. Look, government's giving me all this stuff, right? All of this stuff. And yeah. And, you had fake companies, etc. If you do things like that, that's going to be just like, okay, that's the perfect criminal prosecution. They really like that spending, right? They really like seeing people spend that money on things that are unrelated to the business, that did not keep anybody employed. Yeah. Again, there's nothing illegal. Nothing said you had to use that money to keep people employed. But it just looks bad when they can show you had no right to the money. And it looks like you just went to the Treasury, and stole a bunch of money and spent it, So, hey, welcome, taxpayers of America. Thank you for paying for my home. That's probably not a good sign. I know juries don't like that sign. So make sure that the attorney looks at that issue and considers whether, because of the risk of criminal prosecution, there is a second out. It's not nearly as generous in terms of what you will not have to repay and how you would escape penalties and interest. That's going to the Voluntary Disclosure Program, the more general one, run by the Criminal Investigation Division. If you have their Voluntary Disclosure Program, when you enter that, you have your attorney approach them to enter that, because you obviously want to negotiate some things up front before somebody discloses your name. And again, remember, if you're not a member of the bar, on a criminal matter, they can definitely force you to disclose who the person was. So usually you would use counsel to do this sort of approach and say, hey, we'll come in, they work it up. Remember, the big thing you're getting there is no criminal prosecution. They've agreed not to do that, but you're probably going to pay a hefty, you're going to pay no discount, pay the interest, pay the penalties, right? But we're going to let you off the hook of criminal prosecution. There may be other criteria, other requirements and other issues, but we're going to let you off from criminal investigation and waive that as long as you meet the other criteria. Again, that is one you have to seriously consider, and that's one that involves an attorney who's going to look at your case as a prosecutor would look at your case and see whether or not it would appear one of those things like, yeah, this will be good because we'll probably carry this in front of the jury. And as soon as we carry it in front of the jury, we issue all those press releases, breathe the TV cameras out, etc. And that'll help us get other people into the program, having scared them with this one. So yeah, be aware of that. Now, the second development we have is from the National Taxpayer Advocates blog. And this is a blog entitled, "Did you receive a notice of claim of disallowance for your employee retention credit refund claim? If so, now what?" The blog was published on August the 21st, this past week. And it discusses a lot of this stuff the IRS has just done, but with a focus on those who received one of those 30,000 notices, guys, we have disallowed your claim. Bingo. Claims disallowed. You asked, we're saying no way. Sorry, done. What do you do with that? Well, the advocate wanted to begin on a positive note. So, she did note that the IRS has done some things she approved of recently in the recent weeks. She notes they are beginning the process of claims to issue 50,000 refunds for claims they identified in the process they're using. We'll talk about the process they're using here in a second. They identified for that process had a very, very low probability of being fraudulent or being ones that shouldn't be granted. They're going to start processing those checks. So 50,000 taxpayers, they basically have set those aside. It'll take, you're not going to get notified quickly, but they're ready to process those 50,000, right? And go ahead and move on them. They also announced, and which she also, credited as a good thing, and that case we talked about a few weeks ago here in Arizona, where the district court was deciding whether to order the IRS to, basically end the moratorium. As you noted in that case, or as we know there, the court was very, very disturbed about the fact that it appeared that September 14th date could stay in place forever. Well, the IRS is now backed off, and they're going to say we are going to process claims we have received through January 31st, 2024. That date is not accidental, although it may end up being irrelevant. January 31st, 2024 is the last day to file a claim if the Senate were to enact the bill that the House passed on that date, in 24. That would have been the last day to file a claim for refund. So they are holding off, and I think the IRS is still kind of backdoor hoping that Congress, the Senate, actually passes that bill. And if they do, or we somehow get a revised version of House and Senate pass that, but that date stays in place, then everything that came in after January 31st can just be tossed, right? Sorry, guys, you were too late. You can send out disallowances on all those right away, for the most part, and we're done. So I don't expect them to move past January 31st, for a processing date until after the end of the year. I mean, once the end of the year comes and this Congress, is done, and we swear in a new Congress, then they'd have to restart the process anyway. And at that point, I think it's highly unlikely we're going to see that January 31st, 2024 date revived. That gets really, really far out from the past something to terminate a statute when, there is a limit as to how long Congress can do it. They might argue that, wait, well, we told you that was going to be done. But the courts are going to be more and more apt to say, nope, sorry, guys, that was the prior Congress. You're the current Congress, your powers, etc. So I don't think that date will hold unless this Congress passes it. I could be wrong, so don't ever, I have no idea what Congress will do unless I did what the courts will do. So, basically that happens. We'll see what happens. But I suspect that, yeah, the January 31st date is one that depends on that House bill being passed. House bill doesn't pass this Congress, then we're probably done with that and the service. I wouldn't be surprised if, in fact, we got to the new Congress, if we didn't see the IRS issue a notice, that they were just going to process all claims they have on a first in, first out basis. And so get rid of that date beyond which they won't look at things. But now she goes into but there's some issues here. She notes that tax professionals have raised questions about issues with the denials that have been received. And I've heard these complaints as well from various sources, who have said the specific, very, very similar things from time to time as to what they're saying. Claims that should have been allowed have been rejected by the IRS with no contact from the IRS, nor anything approaching a complete explanation for the denial. In fact, some have said it's clear they never looked at what was submitted, because they didn't even know what the submission that we were going for, not decline in revenue, but partial suspension, or vice versa. We weren't going for partial suspension. We were going decline in revenue, which we, decline in gross receipts, which we submitted information on, but nobody looked at. So as I said, things like that. So IRS does that, and the no contact is, unfortunately, the way the program is working. So we'll talk a little bit about that. That's probably unusual. But again, claims prepared that appeared on their face to the professionals to have all the data the IRS reasonably should have needed to make a determination. And as you might guess, the professionals also assumed that the service would contact them for any other data. I wasn't quite sure I wanted to go with that. I didn't do a ton of these claims. I talked to a lot of people about them, but I didn't do a ton of these claims that we were involved in. But I usually decided that I wanted to submit everything because I thought the service is flooded. And if I can just give them something where any question they've got is answered right now, that's probably going to put me in much better stead than not sending data in and figuring out, going the old line of, well, just say as much as you have to, and then waiting for them to call back, because I had a feeling something like this was very, very possible, that they might just, get overwhelmed. And if it's not there, we're tossing it. Bye. No, we're done. Okay. Many of the notices, also more troubling, failed to provide any explanation to the taxpayer about their appeal rights. And they do have them in this case. Now, we're going to talk about how they're imperfect appeal rights, but they have them and they weren't mentioned. So there were no appeal right mentioned in the letter. As I said, that appears to be a major oversight of the service and a problem that the service has admitted happened with those notices, which of course they claim they're going to make good by sending out notices. But as as taxpayer advocate notes, and I would be concerned too, the question is, the clock's already started running on these to get things done. You really should reset the clock on anybody who didn't get the appeal rights notice and restart the clock. Say the notice of claim, we're going to treat the prior notice of claim as being withdrawn, notice of denial as being withdrawn, and issue a new one at this point with your notification of what your appeal rights are. Okay, now what you have to understand, and what the advocate points out here, is this is a very, very not normal IRS examination process, or at least review of claim process, right? These claims, we did something very, very different, the service did, than they usually do when somebody files a claim for refund. What the IRS had done in the program that led to the 30,000 disallowances and the 50,000 that we're going to pay out, and a whole big group in the middle that are in the, okay, more work's needed area. The IRS did a risk scoring analytic process on every claim. So for those of you who remember your A&A backgrounds, analytic review. They are doing a overall broad looking at running some numbers, running some information, and doing that sort of broad-based analytic review, not really looking in detail at a claim, but running some basic analyses and using that to identify claims that appear to be based on, and I should say this is also based on information they have from the prior claims they've worked. And what they know have been the fraudulent bad claims and what have been true about claims that have been approved and clearly, and there's no question they should have been approved. And what they determined was using that as their model and then comparing the ones they have, they scored, their scoring returns either as, bad, bad, highly unlikely this claim is valid, as very good, highly likely the claim is valid, and then in the middle where it's not close enough to say clearly based on this analysis whether it would be pay the claim right away, deny the claim right away, so there's more work. Now the problem is they're not really telling you why for sure you lost, or they are giving you reasons that in some cases don't make sense. For instance, more than a few people have reported that if the employer that was reporting it was a disregarded entity LLC, which therefore would have its own employer ID number, that the IRS seems to have rejected a number of those because they couldn't find an income tax return. Of course you couldn't. It's a disregarded entity, right? The income tax return was filed, but was filed under the ID number, and it's part of the return for the ID number of the person or entity that held 100% of the LLC. And it definitely appears there are a number of those that got missed, where the IRS disallowed on a disregarded entity just because they couldn't find an income tax return. So yes, failure to file a tax return, basically there is no business. Yeah, that was true of a lot of the fraudulent claims, but how they're determining that on that basis by looking for income tax returns, that's pretty clearly a flawed process. If you don't take into account single member LLCs, that would be disregarded entities that could be owned by a corporation, an S corporation, C corp, S corp, a partnership, right? Could be an individual that owns it, trust. It could be all kinds of things that own it. And that would explain why you would see an employer ID number for payroll, but you wouldn't see any, employees or other, any income tax return that would be associated with that ID. So that was a problem. As I said, also just problems where, they didn't really analyze. As I said, I know of one case where they simply appear to have totally missed that this was not a claim being filed for partial suspension, but was being filed because there was a documented reduction in gross receipts. That could go on, but the service missed that. And obviously, whether or not we can say the claim is right otherwise is different. But clearly, if you're claiming, yeah, there was no court order, or not court, I should say, there was no government order that's, that suspended or partially suspended your activities that applied to you in that state. It's like, well, that's not the issue, right? It was the revenue side of the equation, and you just went down the wrong path. So yes, we have that bad issue. It also means why things like that are missed is because nobody was actually doing a full-blown review of the claim. They were simply classifying returns into whether they look like a good or bad, or we need to talk some more return. That led to it. No examination is conducted, and you're never given the opportunity to submit information to support your claims beyond what was with the 941X you sent. There was no additional data that you could present, and there was no true examination. In this case, so you still don't get the notice of deficiency. Normally, if I file a amended return, let's say asking for a refund, I will get the notice of deficiency after a revenue agent has looked at the return and, taken a look at what we submitted, corresponded with us if they need more data, allowed us to submit more data if they tell us they're planning to disallow it. And then at that point, we'd get our notice of disallowance. At this point, though, we're skipping that whole process. So that's huge. We have skipped that process entirely. So when you file appeal now, instead of going to the Office of Appeals, it's simply going to be taken by the IRS, and now they're going to hand that case to a revenue agent who is going to make their own separate determination, actually reviewing the claim now, looking at the claim, reviewing it, potentially contacting you for additional information. But in any event, when they finish their process on this, if they decide the claim should not be paid, they could decide to pay the claim. In which case then, claim is paid, and you're probably happy, we assume, they paid the whole claim, and we'd be done. But if the agent decides the claim should not be paid, then they make that formal finding, and then they hand that over to the Office of Appeals. And so your case doesn't go to get in line at appeals immediately. It has to go through what is effectively the exam at this point, right? Let's be honest. Now, the IRS is not calling it an exam, but as the blog said, if it looks like a duck and walks like a duck, it's a duck. This looks like, walks like, talks like an exam. This is the exam, but it takes the place after the notice of denial, disallowance has been issued. So it's backwards. Important to understand the backwards nature of this program, right? Now, the advocate points out that this may create what she refers to as a ping pong possibility, which is going to extend time dramatically. Anybody who's been around appeals knows they generally do not consider additional information. If there is significant additional information that the taxpayer brings into appeals, they will almost always kick it back to exam, because appeals, kind of like the courts of appeal, we look at when you're appealing a case from a tax court, if there's some factual issue that wasn't fully developed, that the Court of Appeals decides, well, we need to get this developed, they just send it back to the trial court. They don't hear the case. They don't make a ruling on the facts. Generally, they just kick it back. Appeals generally does the same thing. They're there to hear arguments over the law, right, and applying the law to the facts. They're not there to develop the facts. So if, in fact, there's additional information that was not reviewed by IRS before the notice of deficiency was issued, and you bring that into the exam, which, of course, if you have no information regarding what went on, they just disallowed it and told you, yep, we disallowed it, we got a letter of disallowance. It goes on to appeals, and eventually, and nobody ever contacted you, your first chance to bring up additional information will be at appeals. And as soon as you do that, they're going to send it back to exam, which is essentially a ping pong process, right? We're bouncing around. And we're going to go over why this bouncing around puts you at some risk, but it's there. So what's going to be a long process, and look, given the number of accountants, attorneys, etc., I've heard complaining about disallowance notices they've received, I suspect appeals is going to be very, very busy here shortly dealing with these cases on the 30,000. And remember, there's a whole bunch more coming. So I think the problem is this is going to be burning up time. And as we'll discuss, this is time we may not have. Because even if we had all the time in the world, your client is still not getting the money. And assuming it's justified they should have it, this is becoming a bigger and bigger problem. They might not survive long enough to get paid. That could be a serious problem if they still are, they haven't quite recovered from, all the things that happened during the COVID emergency. And they're still trying to scramble to get back on their feet. And they need this money. There's that risk on the side. That's a problem. But as we'll discover, we got an even bigger problem coming up unless we pay close attention. That's there. Okay. Now, she does make a suggestion that the taxpayers might be able to speed up the process by asking to enter the appeals fast track program, which is a way to speed up claims and get things down and done quickly. Will these be? But she says, but it's not clear that these claims would qualify for that program. And she suggests that the IRS clarify that at least why, at least in some cases, cases where this could qualify for fast track, what the conditions would be. Because if it can, then yeah, it's a big deal, that we could go that route. I don't think the service is going to agree they can. So I think this is her trying to, maybe guilt them a bit, but I definitely don't see that that's something they're going to do, but maybe not. A big thing she notes, though, towards the end of her piece, is that filing an appeal does not suspend the statute of limitation for filing suit in federal court, district court, court of claims, to challenge the IRS notice of disallowance. You have 2 years from the date the IRS issues their determination. And that notice of disallowance is their determination. Going to appeals at this point is like, ending up at appeals when we are looking at, still talking to the IRS after the 90-day letter's been issued, right? Not going to do you a darn bit of good to talk with them. Yes, they might say, oh yeah, let's talk, we might be able to do something, but that clock is running and you better make sure the clock doesn't run out. As I tell anybody in that case, if you don't have it withdrawn, and we are within, let's say, 2 weeks of the 90th day, you better get the tax court petition ready to file and file it. Because that 90th day is going to expire. And if they haven't withdrawn it by then, sorry guys, our hands are tied, and you didn't file a tax court petition timely. So tough luck, guys. And we're not I shouldn't say we aren't. Some of you may be in the Third Circuit, in which case then you might have an outside chance in a case like that in a tax court to get in. Since they do have equitable relief issues that the Third Circuit believes you have. No, apparently the IRS does not believe you have anywhere else in the country. But generally, yeah, we're not going to want to go that route. We're going to want to go with something different. So the problem is, from the date of disallowance, you have 2 years. And the problem is, if your case gets backed up in appeals that's overloaded, right? And there's no reason to believe that the IRS or Congress is going to add a huge number of appellate conferees, that we would have to get up to speed quickly, and that we wouldn't need after this is done. So I'm not sure how you produce that group. I'm not sure where you find that group, right? And I'm not sure, and then who's going to take it if they're qualified for all that background, who's going to want to take that position knowing that, hey, you do your job and you worked yourself out of a job. So yes, we're going to have it backed up like mad, and things are going to be there. So if you do it, even if the appellate conferee now agrees that you should have gotten your refund, if that 2-year statute has run, the refund can no longer be paid. Right? Legally, the IRS cannot pay the refund. And the law is very clear. We had a case on this we talked about earlier this year, where nobody at the IRS can really, anything they say doesn't change that. Right? You would have to go through. The only way to keep the thing open is to formally request an extension of the statute, Form 907, and get the IRS to agree to extend the statute. So this is the reverse of what happens when you've got an exam running on a filed tax return, and the IRS shows up, a number of months before the statute would run and asks you to sign the, extension. And you decide to say no, then they have to go issue their final notice of termination. And yeah, it starts the process that way. Now you're the party that's going to have to start doing something unless the service will agree. So as we get close, like the IRS does, don't wait till the last week to ask for this. Ask for it early. And, if they aren't moving, then you're going to have to make a real call. Are you filing suit? Right? It's put up or shut up time. So if you get in this program, I would say having informal discussions early on about whether or not this case makes sense to take to court, And would it, what cases, how should we do this? That's a whole thing that probably you need to have a discussion with right now. We have this disallowance, the clock's running. We need to face facts that if we cannot get this resolved in appeals and the service does not extend the statute or allow us to extend the statute, the only way to get this refund would be to go to court. And that's got its own issues, right? Going to court may be far too expensive, right? There are cases, let's be very straightforward. There are situations, if you're looking at a $100,000 ERC claim that the IRS has disallowed, if you need to file in district court and go through discovery and all the other parts and that process, you will probably discover that by the time you add up all the costs, not just the direct costs such as legal fees, which are going to be big enough anyway to cause a major problem, but even indirect costs like lost productivity as various people in the company have to deal with this case instead of making money for the company, and discover there is no way it makes sense to take this case to court. I doubt a $100,000 case would make sense. I doubt it. I doubt the numbers could work. Right? You could end up at the end of the day, even if you win, all the $100,000 does is start compensating you for the additional costs you've incurred since you decided to go to court. And that's not really much of a win at that time. And again, it's not easy to get an award of legal fees from the service. And if you do, under federal law, it's capped. So it's probably not going to be your legal fees anyway. So yeah, we have all kinds of issues that make that interesting. Therefore, the taxpayer advocate reminds taxpayers it will be very important to do their due diligence in selecting an advisor to advise them if they should continue to pursue the claim, if they have a disallowance. And as I would state, remember that the party that filed the claim for you, especially if that party is one that is paid by you getting paid the claim, right? So the claim coming out, they'll be paid. They have, in essence, they have an interest that is not necessarily totally aligned with you on all points. They may not, worry about this. Now, also, somebody's got to consider if there is a guarantee of paying for this, let's say, representation. A, can they do it? Do they have the resources? B, because again, they got a whole bunch of claims that are being challenged. Are they going to be able to pay for all that anyway? But B, what's the quality of that representation? Having representation paid for that's low quality, that takes a claim that should have gone through and manages to lose it, that's probably not an advantage of having that. And you probably want to have a third party look at it anyway, just to say somebody who has no, they're not reviewing their work in any way, shape, or form, just saying, look, here's your claim. Here's what we think it would cost if the IRS disallows the claim. You go to court, etc. Here's how much we think it's going to cost you to go through the appeals process if we can get that done before the 2-year statute runs out, or the service. And let's assume the service won't agree to extend it. And have a game plan about where do you give up, and make sure you have competent advisors. You have to convince your clients. And if this is one of those where, as I think some people are going to discover, you had no idea your client filed for this until they come in with this letter of disallowance. And then you got to have a discussion with them saying, look, first thing is, I knew nothing about this, right? You didn't ask me about it. I would say, I think before I could advise you one way or the other, I need to see what you filed. I need to see the data. I need to see their report to tell me why they say you qualified. And I'm charging for that. I think to be very clear. I'm not, they took it on a contingency. Fine. That's what they did. I'm not taking it. First thing is, I really have trouble taking it that way for a whole lot of reasons. But number two, you need somebody who is going to simply be paid regardless, who will tell you flat out their interpretation. I don't make more money if you go forward. I don't make more money if you don't, right? In essence, I work either way. It's fine. And give you the straight up of, how solid is your case? Does your case appear? How much of a chance do you have getting it through without going to court? Because it could be the greatest case in the world, but if we got to go to court, that changes dramatically, figuring out what to do next. And then make that analysis and make that call. And you may need to bring in both an outside accountant and an outside attorney, because there are both legal and accounting issues in play here that you have to realize to make sure. An accountant's going to be very, very good at finding out how good your facts are. An attorney is the expert in helping determine how well your facts fit the law and how that'll play in front of a judge. That's also important if we have to go to court. And also how much all that's going to cost. And both of them will have to feed into that side of the equation. So in any event, I suggest you read the blog. I also wrote up an article on this one. So that's also, you might want to take a look at the current federal tax developments.com site. We have a write-up about this blog. I think it's a very, very useful. It is a very helpful blog to read if any client's gotten a denial. It helps outline what's going on. It helps to show the problems. And for you as an advisor, the parts that talk about the issue with the statute and the problems, that can be very useful to tell a client, look, what I'm telling you here's what the National Taxpayer Advocate says about this. And this is a problem. And, it's going to be a mess for this to get straightened out if it goes this far. And recognize very real possibility that, at some point, it's not going to make sense for you to keep moving forward unless you've got a really, really big refund claim in play. So bottom line, not everybody's claim, is going to make sense to take into the U.S. Supreme Court, assuming they would hear the case. Even if they agreed to hear it, it still might not make sense to take it there because it would cost too much money by the time you went through the district court or the Court of Claims, went to the Court of Appeals, and then went to the Supreme Court and paid for the trials in all the cases. The trial, the hearings in each case, all the briefs, all the other stuff. It's like, yeah, time that's paid for probably doesn't make sense anymore. So this has been the Current Federal Tax Developments for August the 28th, 2024. Current Federal Tax Developments are brought to you by Kaplan Financial Education and by your state society of CPAs. I do watch and keep track of things on the various State Society Connect sites for Arizona, Idaho, New Jersey, Minnesota, Illinois. Do those states, take a look there. I also am, and keep track of, to some extent, the email address, edzollers@currentfederaltaxdevelopments.com. It's going to get a little more interesting over the next few weeks because we are obviously heading into drop dead extension deadline dates. We are coming up. We are within a month now of the first one, right? Which comes up at September 15th for our calendar year taxpayers. So yeah, we got some things happening here. We want to make sure we get those things done. So be aware and take care. We will be back next week, hopefully, with more updates of what's going on in the area of current federal tax developments.